Good afternoon, folks. Well, it's a pleasure to be here and to see you all. I'm very grateful, obviously, to our chair and to the conference organisers, particularly the conference organisers, for putting us in the final session. Being in the final session, you know that whoever's left is really interested in what you've got to say. So clearly I've got the right audience in front of me, or maybe you're waiting around for the talk after me or before me. I'm also grateful for them putting our presentation just after Gulshan Rai, because it seems like he set up all of the issues that we want to talk to today around critical infrastructure, cybersecurity, and what Asia can go to and do next. Now, myself and my co-presenter, my co-researcher, Dr. Saskia Hufnagel, will be doing a two for the price of one presentation. So when you get bored of my voice, she'll step in and brighten the mood, and then I'll come back on to bring it back down again, because you don't want to go home too excited. So Saskia and I, we both work at the Centre of Excellence in Policing and Security, and together for the last 3 years we've been working on some research looking at critical infrastructure protection and government coordination. Now, this has taken in a wide range of different themes empirically. Today, what we want to talk about is, well, we picked out one in particular which we think has relevance to this conference and hopefully is of interest to you. And that's really around how the government is responding, governments are responding to the internationalized threats, emerging internationalized threats. We picked out two particular case studies which we think bear out the themes we want to explore, and that's looking for Saskia. She'll be exploring international, actually I can move on to the next slide. She's going to be looking at international and Australian cooperative approaches to delivering security. Myself, I'm going to be looking at the diversifying cyber threats, and I'm looking at that in the UK context. Although don't let the parochial nature fool you, I think there's a lot of lessons for us to learn here today. So to begin, it will not have escaped any of your attention, and from the amounts of beeps and flashes going on during the conference, everyone here seems to have a mobile device. Everyone here is connected, or internet connection notwithstanding here. We're an internationalized and interconnected society now, economically, socially, politically. We live in a society now where information flows are rapid, are immediate, and are accessible. This is the new global cyberspace which now reaches, it seems, into every corner of our lives. Now, this integration has so many benefits, and I would be here all day if I was to talk through them all, but the finance sector has particularly benefited, and we might want to kind of revisit the way in which they benefited from that in 2007, but that's another talk. Commerce, industry, and civil society all benefit from a globalized, interconnected, and to some degree interdependent world society. We see significant efficiency gains in what we call the social goods. So literacy in developing worlds is being increased and made more accessible through the internet. Education, wealth, healthcare, all of these things are benefiting from a global interconnected society. But this has now come at a cost, it seems, that modern society faces far more threats from an international nature. And that's what we want to talk about today. Our view, and these are the premise of our talk today, and the premise of our research, is that to counter internationalized threats, states increasingly need to have a coordinated response. It's no longer possible to paraphrase John Donne, to no man is an island. Well, no country anymore is isolated. North Korea's trying. But the rest of us are no longer isolated from one another, and the goods that an interconnected world brings is offset by perhaps what we might call the bads an interconnected world might bring. So, our premise is that ideally to guard against cyber threats and international terrorism, we need to have coordinated legal international structures. So, ideally perhaps legislation, treaties, institutions would counter the international threats that we face. But that isn't always possible. Differences in legal systems, differences in political interests, although at this conference there's not been any differences of political opinion. Has there? differences in criminal laws, procedures, state interests, human rights requirements, the list can go on. These requirements make formal collaboration increasingly difficult, tough. So, the premise that we're operating from is that states actually are being a little bit more circumspect about the formal agreements and preferring soft and informal agreements, not necessarily legally enforceable, but nevertheless useful to help them navigate these tough areas. To look at this, I'm going to invite Saskia to present our first mini case study on the history of law enforcement cooperation. Saskia, this is lightening the tone now. She's much better than me.
Thank you, Timmy. And we didn't even rehearse that, but I think it's fantastic that you say the German to brighten the mood. That's probably the first time anyone has ever said that. Thank you very much to IDSA for having me. Thank you very much to the director, but thank you in particular to Uttam. And I have to continue with the sort of nationalist jokes. Uttam had the fantastic job of dealing with a completely neurotic German, inviting me to the conference and bringing me here. And I have to say, he beat me with my own weapons. He started to write me all these emails saying, like, do this, do that, and he completely reversed the whole thing. So it was fantastic. Thank you for having me. What I'm going to talk about today is not really, it's a very big case study, because history of law enforcement cooperation in the field of terrorism is a very big history. And I'm going to focus on the fight against terrorism as one of the major threats to critical infrastructure, but also I'm going to focus on how it is dominated still by informal structures, informal cooperation networks. And here I already have to bring a caveat, because at the international level, the fight against terrorism is completely informal. At the regional level, and my example here is the European Union, because that's where I'm from, I think I mentioned that before, is partly informal and partly formal. So we have sort of a 50-50 divide between informal counterterrorism networks and formal counterterrorism networks. And the networks are not 100% focusing on terrorism. The networks are, Europol, for example, focuses on a lot of things. It doesn't only focus on terrorism, but it's part of its responsibility. Another one would be Eurojust, another one would be COSI. So these are formal mechanisms established in the European Union. On the other hand, the European Union has the counterterrorism group. The European Union has the police working group on terrorism, and they're completely informal networks, and they work 50-50%. And a really interesting story I will tell you, that's the predecessor to Europol, was TRAVI. TRAVI was formed to counter terrorism in 1976. TRAVI was a police group, a police working group on counter-terrorism, and it was situated outside of the EU framework. And the European community thought it was a great idea to incorporate it into the European community formalized legal framework. And so they pushed it into Europe, and after about a year, they said, we're going to leave. We're not going to stay in this legal framework anymore because it's too binding. We cannot cooperate in our field against terrorism in that restrictive setting. So they left the European legal framework again. And this is what you can see with these networks. They need the freedom of the informality, and they don't have that in a European community or today European Union setting. So this is one of the major problems. Now, the next level is the federal level, and I take that as the third level of investigation, because at the federal level we have a high formalization of counterterrorism. So in Australia, all the counterterrorism responsibility has been pushed towards the Australian federal agencies. It's been pushed towards the Australian Federal Police, the AFP, it's been pushed towards the Australian Crime Commission and ASIO. And that could have extreme upsides, and my question is, does it really have extreme upsides, or is the formalization even a downside? And obviously we can see an Australian model will never be a model for the international realm. An Australian model will not even be a model for a regional EU realm, because as you might have heard, Europol will never have enforcement powers. I mean, never say never, but it doesn't look like that at the moment. And so I'm claiming that we don't want that anyway, because having federal structures is not always the best way to fight terrorism. Now, at the international level, we have two major mechanisms or strategies to fight terrorism. The first one is Interpol, and Interpol already has, like Trevi had, a terrorism background. And I call Interpol actually an informal organization. Why am I doing that? Because I'm a lawyer, and things that are not legally enforceable to me are not legal. And the Interpol constitution is not legally enforceable. That's why Interpol always struggles for membership fees. Yeah, because its members are not governments, its members are police forces, and they are supposed to pay membership fees, but many police forces don't pay, and therefore it doesn't have money, but it also can't enforce that payment. So it's an informal constitution. And Interpol and its relation to terrorism, there's a big debate in my field. We're about 10 people. And 5 of us claim that Interpol was formed in 1898 with the assassination of the Empress Elizabeth of Austria in Geneva. And there was a secret international conference of police leaders, and that took place in Rome, and that had a focus on terrorism, which is actually really interesting, because the Interpol constitution excludes terrorism from what Interpol can actually deal with. Yeah, Article 3 says you cannot deal with terrorism. Now, after 9/11, that has been reinterpreted, so Article 3 can now actually be interpreted in relation to political offences as well. But that was the origin, in my mind. So the other 5 people say it was 1923, and it was founded in Vienna, and it was then called the International Criminal Police Commission. Why I'm telling you that story is the word secret. Yeah, it was a secret meeting. They were not sort of an open, an accountable, a legitimate community. They were a secret meeting, and they are now much more open, but they are still not formal or legalized or anything like that. And that brings problems, and it has brought problems not only in relation to membership fees, that's the smallest problem they have, but it has brought problem in relation to abuse of Interpol. And Interpol has recently been very often abused, and Interpol has been abused against political opponents. So some countries have given out red notices, which is like an Interpol arrest warrant, against particular people, and when these people who were considered by those countries, and I can say one of the countries was Russia, were considered enemies by that country, wanted to leave, at the airport, there was the red notice, and they couldn't leave the country. So they were basically put under house arrest, abusing Interpol. And there's not much you can do about it. Yeah, there's no court who can really look into this, apart from national courts, and they obviously wouldn't. So there's a big problem with Interpol. Then liaison officers is another, or is the second real international cooperation mechanism in the field of terrorism. They actually didn't evolve through terrorism, they evolved more in relation to drug crime. So the first liaison officers were sent out by the Netherlands and by Germany, and they were sent to Bangkok. Why? Because that was considered to be, in the 1970s, the hub of drug crime. So that's where the first ones were sent out. Australia, interestingly enough, had the first ones out in relation in Malaysia, and that was in relation to illegal immigration. And terrorism came much later into the focus. But they there are not many cases where we can say that there are major breaches of liaison officers. Liaison officers, and we might have people here who've worked with liaison officers, they abide by their home legislation, they have to abide by the legislation of the host state they are posted to. They can't actually do anything operational, which is obviously a joke because they do it all the time, but they are not supposed to have operational competences in the country they are sent to. And so there is sort of a framework. There's also a bilateral framework, so there are laws or there are agreements between the states, but they don't really focus on the operational engagement. So they have a wide discretion as to what they do in the country. And a very recent case, 2010, was the Dutch liaison officer to Turkey who employed a Turkish civilian infiltrant in the Netherlands. And the infiltrant did his job, the drug people were caught, he returned to Turkey, was killed. Yeah, and civilian infiltration is not even allowed in the Netherlands. Hence, all the evidence that was brought by the infiltrant wasn't allowed in front of the Dutch court. So there are problems there, and we could look into, wouldn't it be better to have at least a partly formalized framework to deal with these mechanisms? Then we could say, okay, here we have a formalized framework. Is having a federal police the best way forward? In Australia, the federal police is competent for terrorism. It was also formed because of terrorism in 1979, because of the Hilton bombing in Sydney. Its predecessor was formed because there was an egg thrown at the minister, and that was seen as an act of terrorism as well, but that's not as much as important as the Hilton bombing. The problem with the AFP is they do actually have very little cooperation with the states, and they have very little cooperation with the other agencies that are coordinating terrorism. So there's already a cooperation problem here as well, although you only have one, or you only have a couple of agencies that are competent. However, they also have another problem. They are an Australian federal police. They are not actually police officers. They are police officers. The other states call them plastics for good reasons, because they are highly compared to the states, intellectual officers at a high educational level who do international engagement and things like that, but they haven't walked the beat, or many of them haven't walked the beat. And so we had the Hanif case where Dr. Hanif was arrested in Brisbane for terrorism charges, and the AFP held them on these terrorism charges, and all the state police who had seen the evidence said the evidence is not enough to hold him. But the AFP wouldn't see that. They had a terrorism case, but they didn't actually know the practicalities of the case, and therefore Hanif got, luckily, a good compensation for what he had to endure. Now, this is a table where I put in other regions of the world, but what we're only interested in is Australia, where I say it's a very low level of formalization, which is actually not true. It is deformalization, but it's a very low level of cooperation. Then we have the international level at the end, and we can already say, why don't we have cooperation? Why don't we have formalization of cooperation here? Well, the reason is because the human rights requirements between all these countries are so different. We cannot actually have a rule that forces us to cooperate with each other. And then we have the most interesting one, the EU in the middle, which is a 50-50 sort of formalization and not formalization. But out of all of them, the highest level of formalization in relation to terrorism. And Monica Den Boer and her colleagues have already said in 2010 that having such a divide in counterterrorism networks, having a partly formalized structure in counterterrorism network and a partly informal structure is actually the way forward, and at least we can raise the human rights and data protection standards if we have a partly formal structure. So that's basically what I'm putting forward, because I'm not very happy with the federal structures, that we might have to look into a balance between informal networks and formal networks to make the fight against counterterrorism not only effective, but also human rights abiding. Thank you.
I've not quite finished yet, Chair. Thank you, Saskia. We're just moving on to the next part of our presentation. We're 20 minutes in, so we've been allowed another 10 minutes by the Chair, so I will hope not to overindulge that. Saskia's kind of overview of international cooperation focused on those informal elements of cooperation and really how they can be appropriately used and perhaps sometimes where they're not appropriately used. While Saskia's case study looks at state-to-state cooperation, I'm going to take a slightly different stance and look at state and private sector cooperation. And the reason I'm looking at this is because in the cybersphere, much of the cyber threats, excuse me, many of the cyber threats that we face are actually targeted at private agencies, private companies, and in the sphere of critical infrastructure in particular, this is of serious concern not only to the UK, which is my case study, but all countries which are looking to privatise their critical infrastructures. So we know that there's a move towards a global economy, and I thank Gulsha Rai for giving us a very good overview of all of the kind of different permutations of the cyber economy and cyber threats. So hopefully I shouldn't have to labour through those for you. There's no doubt that we live in a networked society, and in particular we are witnessing a move to cyber-networked and interdependent critical infrastructures, in which the way in which critical infrastructures are controlled, the data in them are collated, is inherently digital and networked. Now this has a particularly serious implication when you think about some famous cyber attacks, such as the US attack on the Iranian nuclear facility, Stuxnet. Well, I don't think they've declared that they did it, but everyone knows. We know that this is possible. We know that critical infrastructure can be attacked through the cyber realm, and this is something of growing concern. Yet, we live in an era in which upwards of 80% of critical infrastructures, certainly in the UK, US, and Australia, where I could gather data, up to 80% is held in private hands. Symantec in 2010 found that in the year 2011, 67% of companies, in fact that's critical infrastructure companies, experienced at least one cyber attack. And another institute found that each cyber attack on average costs around $2 million, and that's Australian dollars. IDSA similarly found that security professionals working in the critical infrastructure sphere expected a major cyber attack within 2013, and many of those thought that the power systems would be the main targets, financial systems, oil and gas industries. These are real threats and these are real concerns held by professionals in the critical infrastructure space. Yet it's the fact of the critical infrastructures being held in private hands that's of our key concern today. Because we see, and again thanks to Gulsha Rai, I don't need to go through this too slowly, we've seen already that a wide range of threats exist in the cybersphere, from state-sponsored, state-endorsed cyber attackers, issue-motivated groups, or even the spectre of cyber terrorism, which I think still remains a spectre, if perhaps one day it'll be more than that. So we know that there are threats out there. We know that critical infrastructure is critical, well, by nature, to the security of society, its economy, its individuals, and ought to be protected, yet it is held in private hands. So in the UK, the way in which the British government has approached dealing with this is to actually take a two-tier approach. Well, on the one hand, to centralise protection of the minority of critical systems which are run by the government. And so the government, for those systems, have centralised protections, have brought everything within the same umbrella under the Communications Electronics Security Group. They're based in GCHQ. There are a couple of agencies that sit within that umbrella, but the broad point is that government systems in the UK are being centralised. Now that's a bit easier for the UK because we're a unitary state and we don't have so many federal systems outlying which are difficult to bring under the same umbrella. But the centralisation has certainly gathered pace in the UK and bolstered with a hefty investment of £650 million. What about the private sector then? Well, if 90% of, upwards of 80 to 90% of our critical infrastructure is held in private hands, and well, these are systems which are integral to the life and security of the UK, well, what of those? How do we protect those? Well, the fragmentation of critical infrastructure means that the state is unable to produce a cohesive and overarching security strategy which holds everyone under the same standards. There's a fragmentation of standards, of security network standards in the UK across all of these infrastructure owners and operators, which makes it problematic for the government to produce any sort of tailor-made solutions. So as a result, the state has gone about cooperating informally to collate information on threats and dispense advice on how to protect against those. They've done that through one single agency, which is the Centre for the Protection of National Infrastructure, or CPNI, and they host what are known as information exchange mechanisms. Now, these exchange mechanisms are essentially an informal, non-binding forum, secure, in which sector partners, and there are 14 of these, can come together to exchange information on, well, what cyber attacks have we experienced, what have they targeted, how have they gone about that, how severe was the attack, were we able to stop it in time, and so on and so forth, to produce, not only for their partners, but also for the government, some information on how cyber attacks are unfolding at the moment. They also do specific intelligence sharing, which are called WARPs, warning, advice, and reporting points. But the broader point is this, that the only way in which the British government has managed to actually enact protection, such that the state can, in this sphere, is through informal cooperation. The information exchange mechanisms, of which there are 14, including civil, nuclear, financial services, transport, water, food, the list goes on, their engagement in these mechanisms is actually voluntary. There are no legally binding compliance checks. The reason for this, I think, is, well, you may ask the British government, but it seems that the reason for this is that formally binding cooperation mechanisms and measures won't work. That we've already found that even with this voluntary compliance mechanisms, that still companies are reluctant to report breaches of security. Why is that? I mean, why would they not want to tell the government when they're being breached or when their systems have been attacked? And that generally comes down to the fear of the bottom line, that in fact your share price might dive a little bit if you report a cyber attack, a successful cyber attack on your systems, and they're the ones that you want to know about. So there are some risks and some dangers, and the legally binding nature of compliance measures is difficult to attain. So the provision of advice is necessarily ad hoc and partly reliant on companies themselves, which I would argue is slightly problematic. We can perhaps explore that further in our questions. So to bring this presentation to a conclusion, the internationalisation of threats, such as terrorism and cyber threats, has prompted state agencies to revise the way they partner and cooperate with overseas agencies and the private sector. So in policing, this is because, well, we have highly disparate legal systems, and in which the prospects for cooperation, as Saskia has explained, is rather low. Nevertheless, it is possible. Formalisation, nevertheless, cannot be seen as the only way forward. Formalisation and informal mechanisms are likely to be a collaborative, what's the word I'm looking for, a two-handed approach. In the cyber sector, the quantity and diversity of ICT system standards in critical infrastructures actually makes a unified national security architecture unlikely. And so informal cooperation, although it has its drawbacks and it has some clear tensions, nevertheless can allow states to rapidly mobilise to meet these emerging threats. I'll leave it there, and I hope to have some interesting and engaging questions from you there afterwards. Thank you.